In 1973, under the guidance of the Clean Water Act, the state of Arkansas created a list of streams now identified as extraordinary water resources. The list represents water resources that are unique, extraordinary, and have a variety of uses. To be on this list means the body of water is a priority for protection from pollution. Not included on this list is the Illinois River, which flows downstream to Oklahoma. On this particular day, in Tahlequah, officials and environmentalists are commemorating the signing of a contract that will create a 9,000-acre buffer zone along the Illinois River that will filter nutrients from the stream. While efforts are being pursued on both sides of the border to protect the Illinois River, it provides an example of the type of conflict that can arise when a single water source is needed for two purposes.
The relationship between Oklahoma and Arkansas is basically a legal one, and the law is the law of gravity. The river flows downhill from Arkansas to Oklahoma, and that's really the source of our problems, is that decisions made in Arkansas affect what goes on in Oklahoma.
There's been a lot of litigation between entities in Oklahoma, including the city of Tulsa and now the state of Oklahoma, with poultry producing companies that a lot of them are based in Arkansas. Of course, their chicken houses and processing plants are in both Arkansas and Oklahoma. But in the northeastern part of Oklahoma, there are several rivers that have watersheds that are shared with Arkansas. And the Oklahoma Attorney General has decided that some of the environmental problems in Oklahoma are the fault of people in Arkansas, and he has sued some of our larger poultry companies, and some are, of course, based in Oklahoma as well.
In the 80s, when we were attempting to protect this river and Lake Tenkiller from a new source of pollution from Fayetteville, Arkansas, we had to sue, and that lawsuit went to the United States Supreme Court. Under that Supreme Court ruling, it was determined that under the Clean Water Act, a upstream state had to meet the water quality standards of a downstream state. And this was a precedent-setting decision. And ultimately it did work out satisfactorily, because Fayetteville, Arkansas, wanting to discharge half of its treated waste into the Illinois River, did opt to build a very modern treatment plant that removes quite a bit of phosphorus, which is the problem nutrient for this river and for the lake. So it was, all in all, although we didn't win a complete verdict at the Supreme Court, we did win that precedent-setting opinion from the court.
I think what I'd love people in Arkansas to know is that the Illinois River matters to us the way the White River matters to Arkansans. And if they would treat it the same way they would treat the White, we would have a lot less to fight about.
In Oklahoma, the Illinois River is a legally designated state scenic river. And we haven't got very many rivers like this. Anybody who's familiar with western Oklahoma knows that. But in Arkansas, it's, the Illinois River isn't anything very special, you know. It's not a scenic river in Arkansas. And I really wonder if it has occurred to most people in northwest Arkansas that it's vital to us. Tourism is a major element of our economy here. Clean water is important to us. Our scenic rivers are important to us. This river and this lake, Tenkiller Lake, are the apples of Oklahoma's eye.
The problem with the Illinois River is that neither Arkansas nor Oklahoma owns it. They have to share it, an idea which is also the basis of Arkansas's water laws.
Up until the mid-1950s, we didn't have a whole lot of water law in Arkansas. And as the population became more dense in the state of Arkansas, then people started bumping into each other with uses, with land uses, water uses, etc. In the 1950s, there was a dry period that caused a lot of water problems, and we see a lot of case law develop in the 50s. One significant case was decided in 1955 by the Arkansas Supreme Court. It's called Harris versus Brooks. And in that case, the Arkansas Supreme Court decided that Arkansas would follow what's called the reasonable use doctrine for riparian rights. In a riparian system, a landowner whose property touches a body of water on the surface of the ground is able to use that water on that piece of property for lawful uses. Then the court said if a legal use somehow infringes on someone else's legal use, you have to adjust that. Other uses have to yield a bit until you balance those uses.